If this is your first time joining us, welcome. And if you're back, thanks for returning. So I'm Jen, and before I hand over to Charles, I'm just going to give a quick introduction of the ICCP. So who is the ICCP and what do we do? Well, we are a professional members organization that recognizes those with the skills, qualifications, and expertise in the professional management of construction claims. And we have three primary objectives. The first is to establish international professional standards. The second is to give recognition to those who have gained the appropriate knowledge, experience, and skills in claims management. And third, to help and educate those who would like to enter the field of construction claims. And why is there the need for the ICCP when there are so many other construction organizations? Well, quite simply, over the past few years, construction claims have become a key part of the international construction industry, and professionals have come from a variety of backgrounds within construction, engineering, quantity surveying, project management, construction law, etc. And at some point, they have decided to focus on claims. And until the ICCP, there is no institute that specifically recognized those who have the specialist knowledge, experience, and skills to be able to manage, prepare, and respond to claims to the highest level of professionalism. Okay, so I'm not going to go into a deep discussion of our steering committee. I will just say that we have an elected president and 3 elected fellows, and we are currently holding elections. So if you are a member and you're listening to this, please vote, have your voice heard. This year, we will actually be increasing the steering committee to 5 fellows. And that is due to the growth of the the institute. Okay, and in terms of membership, we have 3 levels of individual membership that each have their own criteria. Additionally, we have the special individual memberships for students who are studying their first qualification and then can graduate into graduate membership until they have sufficient experience in order to become an associate member. We also have corporate memberships for companies that specialize in claims or have claims departments. And I know that was very quick. If you would like any more information, if you requested more information when you signed up for today's session, I will be emailing you in the next few days. I'm very sorry. I have tried to escape the jackhammers and the saws. That's why my sound quality is still bad, but if you can still hear it, I do apologize. Sorry, where was I? Oh, if you are interested in learning about corporate membership, please do get in touch and I can answer any questions you may have. But in terms of the benefits to members, we offer a member area of our website, which has a collection of articles, white papers, research, etc., including some articles from today's presenter. We have a collection of resources on where you can find further education and CPD training opportunities around the world, live or online. We also have a bookshop which does not sell books, but has reviews of the latest industry releases. We have a library of practical templates that help our members to ensure that their claims are completed to the highest standard while also saving them time. We have regular CPD opportunities like this one. So most of our CPD sessions are open to the public. However, CPD certificates is a benefit of membership. Okay, we have the ICCP Academy, which are member-only webinars, which are more technical in nature. And members can get publishing and further training discounts from Wiley Blackwell and Rutledge and our training partner Claims Class. We also have a monthly newsletter to keep our members up to date on the industry. We offer industry exposure in a public listing of members, as well as the usual benefits of certificate and logo. We have a private LinkedIn group where our members can discuss their contracts and claims questions and benefit from the expertise of the entire membership body. And we have the optional benefit of the Register of Claims Practitioners, which is popular with our consultant members. So each member of the register has their own webpage offering their skills and their contact details. Okay, I know that was very quick, but as I said, if you requested further information when you registered, I will be getting in touch with you in the next few days. And otherwise, you can visit our website, instituteccp.com, or email me, jennifer.smith@instituteccp.com. And if you would like to watch the replay of this or any of our other public sessions, you can go to our YouTube channel, which is Institute of Construction Claims Practitioners, or visit our website. And with that, I'm going to give a quick introduction of today's speaker. This is Gavin Mulkuya Charles, who is a civil engineer and a recognized expert in the field of dispute resolution and construction claims. So he has his bachelor's in civil engineering, and he is pursuing a master's in civil engineering in structural engineering. He is also currently pursuing a Master of Science in Construction Law and Dispute Resolution. He is a member of the Chartered Institute of Arbitrators and an associate member of the ICCP. He's also a certified mediator and serves as the team lead of CG Engineering Consults, a reputable firm specializing in engineering design, contract management, and dispute resolution. And additionally, he is also the team lead at Resolve 360, a pioneering entity dealing with ADR training, consultancy, and advocacy in Uganda, which means he is well suited to discuss ADR in construction in Uganda. So with that, I will hand it over to you. Thank you, Charles.
Thank you very much, Jen. Maybe if you could confirm if you can hear me.
I can hear you. And before I let you begin, I'm sorry, I forgot to say, if anyone has a question, please use the Q&A box, not the chat box. So at the bottom of your screen, you should see a Q&A box that has 2 speech bubbles. Please use that one, and then your question will not get lost. Okay, now I will really hand it over to you. Thank you, Charles.
Thank you very much. Probably I will just straight away go with sharing my presentation. Then if you can confirm with me that you can see what I'm projecting.
Yes, we can see it just fine. Thank you.
Okay, so for us here in Uganda, it's afternoon, so good afternoon. And to those of you with GMT, I think it's good morning. Our talk today is going to be about construction ADR in Uganda. My name is Gavin Mulkuya Charles, as I have already been introduced by Jen, and I think she has already gone through this. She'll be able to share the slides with us such that you are able to get my contact details. So probably when we're talking about ADR and construction, of course, we note that the construction industry is a hotbed for disputes, and therefore there's a need for dispute resolution mechanisms to be able to resolve disputes in this industry and make sure that projects are able to go on without so much disturbance. Of course, the disputes will always be there due to Murphy's Law. What can go wrong will always go wrong. But I think the presence of these mechanisms helps us to resolve these disputes in a much more speedier and flexible way. So today, for our presentation, I am going to specifically concentrate on adjudication in Uganda, and throughout our presentation, I'll try and draw parallels between construction adjudication as it is in the UK, because they have statutory adjudication and adjudication as we have it here in Uganda. And I will start with this rather long quote by Lord Coulson. For most of us, or many of you who have read about adjudication, you're very familiar with Coulson. And I'm sure you've also referred to his book, Coulson, on construction adjudication. So recently, in that case of John Doyle and Eric Contractors, Lord Coulson really pointed out how and why adjudication as a mechanism on the ADR continuum really stands out, because he says that it's not just a part of ADR, and he talks about it as the only system which is compulsory because it's statutory in the UK that he's aware of, which requires a decision by a specialist professional within 28 days, backed up by a specialist court enforcement scheme, which provides judgment also within weeks thereafter. It is not an alternative to anything. For most construction disputes, it's the only game in town. And of course, very many books and academics also back this up, because most of the disputes, around 80% of disputes world over, are resolved by adjudication. And again, most of them do not even proceed to maybe further settlement or litigation or even arbitration. So I think Lord Coulson was right in stating that. And in this, you can get the many benefits of adjudication. It is fast. The parties have a choice on who can resolve their dispute. Normally, that person is meant to be an expert, and it helps the parties to actually proceed, and most times to be able to maintain their business relationship. So, of course, the main question we would ask ourselves is, what is adjudication? Because I am aware that some people on the call are not so familiar with it. Well, adjudication is a procedure under which an independent third party, within a time fixed period and in accordance with agreed rules, will give an interim decision on a dispute. And that interim third party is normally known as an adjudicator. And of course, that decision normally is referred to as temporarily binding, unlike maybe say arbitration or litigation. And that's simply because that unless it is binding until one of the parties expresses dissatisfaction, and therefore maybe submits it for final determination through either amicable settlement or litigation or arbitration. So that's just a brief about adjudication as a whole and as a dispute resolution mechanism on the ADR continuum. I think what is very important is for us to know that there are three types of three forms of adjudication, that is statutory, contractual, and ad hoc. Statutory adjudication happens where there's mandatory adjudication because there's an act. For example, we are going to look at the HGCRA, the Housing Grants, Construction and Regeneration Act of the UK. And that is one form. In England and Wales, where they have statutory adjudication, where it's mandatory that for contracts that are defined as construction contracts according to the Act, that they must be able to have that clause. Then contractual adjudication happens in instances where there is no Act, where two parties expressly come out and say that, adjudication will be the mechanism for us to resolve disputes in our contract. So that is a form that we will later know is much, much more common on this side. And then we also have ad hoc adjudication, where parties, upon the crystallization of a dispute, are able to come together and sit together and find a way of resolving the dispute through adjudication. Therefore, the adjudicator in that sense gets an ad hoc jurisdiction, and therefore it's easy for him, or it becomes then easy for him, or it becomes possible for him to be able to resolve the dispute through the mechanism of adjudication. Maybe just a small tip here. For us here in Uganda, we do not have such adjudication. We don't have an act governing adjudication. And therefore, the most prominent forms of adjudication that you will find here in Uganda is both contractual and ad hoc adjudication. So maybe now we are going to try and to paint a picture for the different types, that is statutory, contractual, and ad hoc. But for the purposes of this presentation, we will concentrate a lot on the parallels. We will do a lot of comparing and contrasting between statutory and contractual, because those could be the main forms that we are going to look at So statutory adjudication, where does it come from? In the UK in the 70s and 80s, contractors and subcontractors were having issues regarding payments. It was very difficult for them, and because of that, most of them were inefficient. Disputes were prevalent, and there were high levels of insolvency because most contractors and subcontractors could not maintain regular cash flow, and therefore they had to go bust. And after the recession of the early 90s, Sir Michael Latham was commissioned to do a report into the construction industry by both Parliament, government, and industry bodies. And in his report, which he dubbed Constructing the Team, he found that the two key issues in the construction industry that were facing the construction industry then in the UK were issues concerning disputes and issues concerning payments. And his report had 30 recommendations. And from those recommendations, Parliament was able to enact an act, which was later amended, as we are going to see. And therefore, it is that act that has governed the practice of statutory adjudication for over 17 years now in the UK. Of course, we could say that it's one of the landmark pieces of legislation in the construction industry, and quite a number of countries are also trying to adopt statutory adjudication. But as I have already hinted, Uganda has not yet done that, and we are currently working a lot using ad hoc and contractual adjudication. So, as I've already said, the report Constructing the Team had 30 recommendations, but from recommendation 25 and recommendation 26, recommendation 25 dealt with the issue of payment. No, recommendation 25 and recommendation 26 dealt with the issue of payment and disputes. One required that there is an easier way of resolving disputes that is mandatory for construction contracts, and the other also dealt with the issue of payment. And through that, the Parliament, of course, adopted most of the recommendations of the Latham report, and that gave birth to the Housing Grants Construction Regeneration Act, which I abbreviate as HGCRA, and I will refer to as HGCRA 1996. And that act was, of course, because of a few issues after use, it was later amended in 2009 by the Local Democracy, Economic Development and Construction Act, which I will call LDEDCA. Now, it should be noted also that whereas the act was initially enacted in 1996, it came into force in 1998. And it should also be noted that LDEDCA came into force, whereas it was enacted in 2009, it came into force in 2011. Then it should also be noted that LDEDCA was not retrospective in that it only dealt with contracts that were from the date it came into action, and didn't deal with contracts that were, behind. So it didn't act in a retrospective manner, but it acted in a, should I say, prospective manner. It dealt with issues at the front and not dealing with issues at the back. So I think you may find some contracts, more so in the UK, that are still being governed by the 1996 Act, and those that are being governed by the 2009 Act, as we refer to it now. And then also, it was important. So what happens is the Act defines in Section 104 what a construction contract is, or what amounts to construction operations. So contracts that are within that ambit are meant to conform to the Act, and therefore there's mandatory statutory adjudication that has to be part of those as a means of resolving disputes. And what happens is, when there's a provision in the contract that does not conform to the Act, then the scheme for construction contracts, the secondary legislation, comes in with mandatory provisions that can be plugged into that part to either replace all of it or part of it. So the scheme has two parts. That part, it has a part for payments and disputes too, and therefore, for example, if the Act says that pay when paid clauses or pay when certified clauses do not conform to what the Act means, then that means that the scheme will have a provision to replace that payment provision, and that's the provision of the scheme will apply. So that is how the application of the statutory adjudication is now in the UK. And then when we come to adjudication here in Uganda, as I've already mentioned, we have no act governing adjudication in Uganda, but adjudication is a staple in the construction industry, and over 80% of disputes in the industry are being resolved by adjudication. And it should be noted that very few cases really here in Uganda progress to arbitration or even maybe amicable settlement. Most disputes are resolved through adjudication, more so in the construction industry. And the main forms of adjudication in Uganda are contractual and ad hoc. Ad hoc normally happens sometimes because parties may not include a very robust dispute resolution clause, and therefore upon the crystallization of a dispute, then the parties can come together and decide to resolve the dispute through adjudication and probably go to an adjudicator nominating body to get them an adjudicator, or they can just amongst their circles get someone who is reputable in the field to be able to resolve the dispute. So contractual adjudication normally appears in the forms of the standard forms of contracts that we use here in Uganda, and some of the more popular standard forms of contract that we use is the FIDIC forms of contract and the PPDA form of contract. And the FIDIC forms of contract, some of you are already familiar with them. They provide for the DAB or the DAAB, the DAB being the Dispute Adjudication Board, or the DAAB, the Dispute Avoidance and Adjudication Board. Of course, the 1999 forms are more common, and the red and yellow books are more common, given how contracts are formed here in Uganda. Either the employer will do the design, or the employer will leave the design and the building to the contractor. So that is why the red and yellow books are much more common. It's been on rare instances that we've used the silver book, or even the green book, or even the gold book. The pink book is common too, because most of the public procurement and most of the public projects are through MDBs, the multinational development banks. And for some of them, they prefer to use the pink book, the harmonized pink book. So then the PPDA form of contract, that was prepared by the Public Procurement and Disposal Authority here in Uganda. And it is part of a standard bidding document, what I abbreviate as SBD. So part 3 of that standard bidding document is the contract, and part 3, section 7, around subclause 24 to maybe 25 is where the dispute resolution clauses are. And it clearly stipulates that the dispute resolution process will follow these clauses, or the procedure described in these clauses. So, and that is what we are going to see. So now that we have laid a background for both statutory adjudication as it happens in the UK, and then contractual adjudication as it happens here in Uganda, then probably now I want us to proceed to comparing and contrasting the different approaches followed by the different forms of adjudication and application in the different jurisdictions. So what we are going to do is to compare between, I've broken it down into the preconditions to adjudicate, the initiating the adjudication process, the adjudication process itself, and the adjudicator's decision. So we're just going to look at the different approaches, or the differences, or even similarities, because they may not be, there may not be need for there to be differences, but we can just have similar approaches and just compare and contrast. So the preconditions to adjudicate, as we are going to see, section 1081 of the HGCRA is the one that brings forth the adjudication. So the quick questions we'll ask ourselves is there a dispute? Are we allowed to adjudicate more than one dispute? Is adjudication only limited to disputes arising under the contract? What does it even mean for a dispute to arise under the contract? And then, can we commence an adjudication at any time, or the adjudication has to be at particular times? So those are the key questions, or the key conditions that are supposed to be met before we even think about the adjudication. So section 1081 of the HGCRA states, and I wanted to just reproduce it here, that a party to a construction contract has the right to refer a dispute, which is underlined, arising under the contract for adjudication under a procedure complying with this section for this purpose dispute includes any difference. So of course now we come here to when we are looking at this key question, this key precondition to adjudicate, the question about the presence of a dispute. So in the first instance, we can ask ourselves here, does dispute carry a different meaning? Does it mean, what exactly is the meaning of dispute? So in AMEC Civil Engineering and the Secretary of State for Transport, it was held that the dispute should hold, the word dispute should hold its normal meaning. And therefore, the normal meaning of dispute as an English word is what is referred to here in section 108. And also in Fast Track Contractors and Morrison, that is where the description of what exactly a dispute is meant to be. So what happens? How do we say that a dispute has crystallized? How do we say that there's a dispute? What conditions are supposed to be met? The condition is that a claim must have been made by one party, and the other party must have denied that claim. Now, that denial, it's very important to note that the denial may either be through silence, may either be through admission, may either be through total rejection, or may also be through modification of the claim. And therefore, what happens is that there is a claim made which asserts a position of one party, and maybe the other party is not comfortable with that position or does not accept that assertion of that position. And when we have those two, that is when we can say that there's a dispute. Of course, from that, we can deduce that the word dispute and claim totally have different meanings, and just the presence of a claim does not exactly mean that there is a dispute, but the dispute would rather occur when the claim has been denied either expressly or inexpressly by the other party. So when we proceed to the contractual adjudication, because now we are comparing and contrasting about this, how does PPDA and FIDIC attaches? I've reproduced Part 3, Section 7 of PPDA, subclause 24.1, because I think most people are not privy to it. But I think for FIDIC, we are all privy to that subclause 20. So I may not be able to reproduce it here. So in this presentation, I'll only reproduce the PPDA clauses because it's important for us to see them. And then we maybe compare and contrast with the other. So PPDA just says that if the contract, because PPDA, for PPDA, instead of the engineer in FIDIC, we have a project manager. So it's the project manager who is supposed to make decisions on the contractor's claim. So if the contractor believes that a decision taken by the project manager was either outside the authority given to the project manager by the contract, or that the decision was wrongly taken, the decision shall be referred to any adjudicator appointed under the contract within 14 days of notification of the PM's decision. So in essence, this also I think relates to statutory adjudication, because in the first instance, we have to have a claim, and then the PM has to make a decision on that claim, in which decision probably where he's either maybe accepting the claim or rejecting bits of the claim, or totally rejecting the claim in its entirety. So in that situation, we can say that a dispute has crystallized because one party asserted its position, and the other party declined to assert the position. And I think it's the same thing with FIDIC, where we have a claim. I think that's under subclause 20.1, the contractor's claims. We will have the claim, will be in, and the engineer will give his determination according to subclause 3.5. And if the contractor or even the employer is unhappy about that, then they can proceed to adjudication. I think that is under subclause 20.2. So we can see that from that precondition, all of them require that there is a dispute, because in the first instance, what the adjudicator would have no jurisdiction if there is no dispute. So we proceed to the second precondition. Should there be more than one dispute? Can more than one dispute be referred to a single adjudication? That is the question we should ask ourselves, and the question we are seeking to compare between the two. So statutory adjudication, the right is restricted to a single dispute. And in fact, in Fast Track and Morrison, the it was held that the Act refers to a dispute, not disputes. So you can only have one dispute. However, it is permissible to have two adjudications with two different disputes, maybe even occurring at the same time or even before the same adjudicator. That is possible, but you can't have two disputes in one adjudication. I think it also makes sense because at the end of the day, because of the time constraint, sometimes it may be difficult to maybe have a thorough decision made on two different disputes. And of course, we have to make a distinction between issues and disputes, because we can have many issues in one dispute. For example, you could have a dispute on extension of time, and maybe the grounds are whether right of access. Those are all issues leading to one ground, leading to a whole dispute of extension of time. Maybe I've made a claim that my extension of time as a contractor has to be 800 days, but then the engineer says, no, they have to be 600 days. So of course, I've made an assertion and they've made a modification to my claim, and probably I disagree with that, and we move forward to adjudication, but that's one dispute. However, if we have many disputes, then it's not possible through such adjudication to refer that to adjudication. And PPDA also, through its wording, is very clear that it refers to a single PM's decision for referral. So it has to be one decision. And of course, the decision is very important. The decision could also be about one dispute. So that is something to look out for. And FIDIC expressly also says that through that subclause, it expressly says, in case a dispute under this contract or in connection with this contract, so it's just a dispute. So even FIDIC adjudication here has to be one dispute at a time. And of course, there is no preclusion in both the PPDA and FIDIC to two different adjudications at the same time in both, because the PM in PPDA, the project manager, I'm going to refer to the project manager as the PM, the project manager can make two different decisions in, maybe we could refer to different decisions, and the different decisions could all go to different adjudications at the same time. So I think in that regard, statutory adjudication and PPDA and FIDIC, as we apply them here in Uganda, have almost a similar approach. So we proceed to the next precondition to adjudicate, which is that the dispute can we adjudicate a dispute that is substantially the same? So this normally happens, by the way, this is very common, when a party is dissatisfied in a previous adjudication and you feel that maybe that adjudicator did not do a good job and you probably want to re-adjudicate the same dispute. So of course, it was held in VATAS, FLI, and Scrip Group that a party cannot adjudicate a dispute already decided. And of course, Section 1083 under statutory adjudication says that the decision is binding until final determination. But why is this the case? This is the case simply because of two reasons. The first, if an adjudicator has already made a decision on a dispute, then in that first instance, there is actually no dispute. And therefore, if one party wants to refer that dispute, now I'm calling it, back to adjudication, then they fail at the first point where in the first instance, the Act requires for there to be a dispute. So that's one point. The second point is that under Section 1083, a party cannot re-adjudicate. There's no provision for a party to re-adjudicate a dispute. Rather, the party can only proceed for final determination through either arbitration, litigation, or arbitration, and that's the case. So, and that's what was also held in VATAS and Scrip. So that is why it's not permissible in the Act to do that kind of thing. And of course, in PPDA also provides for the same. In case of dissatisfaction with the project manager's decision, a party can proceed to arbitration, and PPDA also does not provide for re-adjudication. So the adjudicator's decision is binding unless referred to arbitration for final determination. It's very important to also note that PPDA does not give the very many options. It doesn't give litigation, settlement, and arbitration as the different ways of final final determination. it only gives arbitration as the means of final determination. And for FIDIC, the approach is also the same as PDA as we apply it, and I think as the standard is worldwide. However, of course, FIDIC, after dissatisfaction and after writing the notice of dissatisfaction to the adjudicator's decision, the parties have a leeway to do some amicable settlement, upon failure, then the parties can refer the issue to arbitration. So those are the different nuances between the different forms of adjudication. Then this is also another key precondition to adjudicate. Is the adjudication open for disputes arising under the contract or disputes in general on the project? So under section 1081, the Act clearly stipulates that the statutory adjudication, this mandatory adjudication, is only available for disputes arising under the contract. And what is the meaning of that under the contract? It means that the cause of action must arise from the contract between the parties. And therefore, as a matter of fact, the statutory adjudication is not available for non-contractual claims. And one would ask, what are non-contractual claims? Non-contractual claims include maybe claims in tort, for example, claims for negligence, claims for negligent advice, claims for negligent misrepresentation. Those claims are all not open under statutory adjudication, because clearly Section 1081, as we already saw it, provides for disputes arising under the contract. So just under the provisions, maybe one party was supposed to provide access to site and did not. That's a dispute arising under the contract. But if the employer wants to claim against the contractor, for example, in a design and build project, if the contractor provided a report that maybe the employer best on to do an act, and then it was discovered the employer suffered damage, then it would be difficult in statutory adjudication for the employer maybe to claim for negligent advice, to claim for damages due to negligent advice under statutory adjudication. Then when we compare and contrast with contractual adjudication as we have it here in Uganda, PPDA also provides for disputes arising under the contract, because most of the decisions of the PM are supposed to be on issues under the contract. So PPDA is also not available for non-contractual claims, similarly to statutory adjudication. Then when we go to FIDIC provides for both contractual and non-contractual claims because of the wording of the clause, because it mentions disputes under the contract and also disputes in connection with the contract. And of course, it was already held in Ashville Investments and Elmer Contractors, the effect that the wording of the contract, most especially when it says in connection with that, it allows for the presence of non-contractual claims. And I already said those are claims, for example, for negligence, negligent advice, and misrepresentation. So those are the tricks, the nuances that one can look at as they're trying to forward a dispute, most especially here in Uganda or even world over. Then also the last one, I think, the last precondition to adjudicate, that is we commence an adjudication at any time. What is the meaning of any time? So in statutory adjudication, that is via section 1081 and section 1082, it means that a party can commence adjudication during or after a project. And I think this also just goes back to Sir Michael Latham's report, where they just wanted something that can resolve a dispute there and then as a dispute arises, such that parties don't have to go into distress to go back to the times of the 70s and the 80s. And of course, the effect of this is that it cuts through those multi-tiered procedures. And it was very, very evident here in City Basements Limited versus Nordic Construction UK Limited, where it was held that a party can actually commence adjudication at any time and they don't have to go through the multi-tiered procedures. You know, there are multi-tiered clauses where a party should first go through mediation, which if it fails, then maybe settlement, then a dispute board, and then adjudication. So it cuts through all that. So at any one point, a party can just go straight to adjudication as a means of resolving its dispute. And then, of course, the question one would ask themselves is, what happens to contractual provisions that fetter that right? And as I already said, they are replaced by those of the scheme. So if you have a dispute resolution clause in a contract that does not augur well with the stipulations of AGCRA, then the mandatory provisions of the scheme will apply. And but our approach here in Uganda is a bit different. Under PPDA, parties can only adjudicate within 14 days after receiving the PM's decision. So you just can't go straight to adjudication, just the way it is here in statutory adjudication. And then also FIDIC permits the parties to refer to adjudication within a fixed period of time. So the adjudication is not flexible as it is here. And for us, in fact, if there is a dispute, if the clause is multi-tiered, then the expectation would be that probably you would have to try most of those before you proceed to adjudication. Yes, now we are done with the preconditions to adjudicate, and now we are going to look at the initiation of the adjudication. Maybe the parties have moved forward, they've satisfied all the preconditions to adjudicate, and now they've moved at a point of initiating the adjudication. So maybe that is the notice of adjudication, appointing the adjudicator, and also determining the overall jurisdiction of the adjudicator. So how do we compare using PPDA and FIDIC with statutory adjudication? So the notice of adjudication is very key because it defines the scope of the dispute. And under statutory adjudication, the formal notice of dispute or formal notice of adjudication is required. And the importance of that notice of adjudication was clearly mentioned or stated in Griffin and Midas Holmes, as you can see, the reference case there. And of course, for you to write as a notice of adjudication, of course, there are drafting considerations. You have to mention the parties, you have to mention the form of contract, you have to mention if the dispute has crystallized, because in the first instance, if the dispute hasn't crystallized, then the adjudicator won't be seized with the jurisdiction to be able to make a decision. So you have to mention how the dispute has crystallized and to also show that the dispute has crystallized. And then also in statutory adjudication, the referring party should set out a relief sought. So for example, if you have a dispute on extension of time or even variation, you should be able to show that there was, maybe we wrote a letter with a claim for variation, and then the same was either not regarded or was modified or rejected by the receiving party. And therefore, at that point, through correspondence A and correspondence B, it clearly showed that a dispute had crystallized, and therefore we seek relief in the order of the sum of this number of shillings and then that kind of thing. So that is how the notice of adjudication is normally drafted under statutory adjudication. Then comparison with PPDA, that is Part 3, Section 7, Subclause 24.1, the adjudicator is seized of dispute upon referral. So therefore, there is no formal notice of adjudication which is required. So the referral is normally sufficient. So in the referral, the parties normally make mention of the dispute and what happened in the what happened in order for the dispute to crystallize. And then they also set out their entitlement or the prayers that they hope the adjudicator will make a decision on. And it's the same approach with FIDIC, where the DAB is seized of the dispute when it is referred in writing with copies to the other party. Of course, writing, or when it is made in communication, according to subclause 1.3, communications in the way that is referred to in the contract. So that is very important. And of course, no formal notice of adjudication is normally required because the referral is sufficient. Normally, when we are making the referral is when we put everything together. We mention the parties, we mention the dates, we mention the type of contract, we mention the different correspondences, the cause of the claim event. You mention your entitlement, and then you substantiate, and then you try and make the prayers of the relief that you seek from the adjudicator, and for the on the issues that the adjudicator should make a decision on. So that could be a bit of a nuanced difference between the two processes. And then we proceed to appointing the adjudicator. The statutory adjudication, the appointment of adjudicator is given for in paragraphs 2, 3, 5, and 6 of the scheme of the construction contracts. And of course, that gives 7 days from the from the date the notice of adjudication is served. So 7 days from then, the adjudicator should be appointed by the referring party. And of course, under subparagraph 2(1), there's also, of course, a discussion about a specified nominating body and an adjudicator nominating body. So a specified nominating body, the parties can sometimes make mention of a particular nominating body. For example, they can mention CIAB, they can mention TEXA, they can mention, for our case, maybe Uganda Institution of Professional Engineers, they could mention RICS. So they could mention those different entities that have the ability to, they could mention ICE to nominate an adjudicator, or there could, or in general, it could just, the clause could be open and just refer to an adjudicator nominating body, and that can be open. It may be that there has been no specified one in the clause or in the contract. So here in Uganda, what happens is that appointment within 14 days of the notification of the PM's decision, the adjudicator has to come on board. And so our wording is within 14 days, but statutory adjudication gives 7 days from the date of notice of adjudication. So for us, this one is 14 days, within 14 days of notification of the PM's decision. And then the normal adjudicator nominating body, for example, for engineering disputes, is the Uganda Institution of Professional Engineers, which is what governs the professional engineers here in Uganda. So it's normally the body that is referred to in most of the PPDA forms of contract. Then FIDIC provides for 28 days after the referring party gives notice to the other party of its intention to refer a dispute to a DAB. So I think here, about appointing the adjudicator, the different forms of contracts, even as here in Uganda, PPDA, the procedure is a bit different than that of FIDIC. So of course, practitioners have to be very keen about what triggers what in these instances. So the adjudicator's jurisdiction, of course, we have to know about the adjudicator's jurisdiction, because without jurisdiction, then the adjudicator has no powers. Jurisdiction precedes powers, and the exercise of powers by an adjudicator presupposes the inherence of jurisdiction. And also, if an adjudicator acts above or below his jurisdiction, then there are also still similar challenges. So when can the jurisdiction of the adjudicator be challenged? The jurisdiction of the adjudicator can be, we have 3 types of challenges: the threshold challenges, process-based challenges, and decision-based challenges. The threshold challenges occur at the very start of the adjudication. If we don't go beyond those, then we can't even have an adjudication in the first instance, because from the very start, the adjudicator will have no power will have no jurisdiction, and therefore cannot exercise any power as given under the statutory adjudication or even contractual adjudication. Then process-based challenges are those that happen, the challenges that can happen during the adjudication process. One of the parties could say, no, we are uncomfortable with this, and therefore they make a challenge to the adjudicator's jurisdiction. Then decision-based challenges, those happen when the decision has been received, or at the point when the decision has to be made and received, and those are made against the decision, or how the decision is made, or certain issues about the decision. So we are going to go a little into that. And so the threshold challenges, and here in this section, we joined all of them. So I'll just be making mention of something and then trying to see how to go about it. So if there's no contract, remember, adjudication is a creature of contract. So for both statutory and contractual, if there's no contract, then we will have no jurisdiction. Therefore, that can be a good ground for a challenge. Then if the contract is not a construction contract, this is for statutory adjudication. Remember, section 104 of AGCRA defines what a construction contract is, and section 1052 makes exceptions of what isn't a construction contract. So if the contract is not a construction contract, then there cannot be a mandatory adjudication provision as given by the Act. And if a contract is not in writing, that was in Section 107 of the 1996 Act, but I think that was amended in LDEDCA. So LDEDCA also can cover oral contracts. Yes. If the dispute has already been settled, we've already discussed this in the first instance, there's no dispute, so the adjudicator has no role. Then if a dispute is not under the contract, here we already say that statutory adjudication and PPDA are similar. They deal with the disputes that are mandated, that are under the contract, and not non-contractual claims where FIDIC, of course, presents a dispute, a difference. And then if there is more than one dispute, then that could also be a challenge because you know, for most of the wording, it refers to referring one dispute. Then the process challenges can include when incorrect parties are named in the notice, and that was clearly seen in Esther and Multifit, where their decision was rendered unenforceable and not binding to the parties because an incorrect party was named. If the adjudicator is not correctly appointed, because that could be maybe because wrong rules were followed, or the correct rules were followed wrongly, or there was a wrong nominating body that was used. Those are all instances when that can happen. So in that process, then the adjudicator has no jurisdiction. If the referral notice is served out of time, for most especially when we have the time bars, if arguments are outside the scope of the dispute, then that means that that is beyond the jurisdiction of the adjudicator. And then when there's also change to the relief claimed. Then the last is the decision-based challenges. Under statutory adjudication, it is not permissible for the adjudicator to hold the decision as lien. Of course, that is a difference if you compare and contrast with arbitration, where the arbitrator can hold his award as lien for his costs. But here it was even determined in Andrews Bay Development and HBG Management that the adjudicator cannot hold his decision as lien for costs. And I think the approach is different from in FIDIC, where the adjudicator can actually hold the award as lien for costs. PPDA is the same. PPDA does not expressly talk about this issue of lien, but FIDIC expressly talks about it. Then failure to reach the decision in time. The PPDA and FIDIC, and I think this is general, most of them really talk about if the decision will be binding or not binding. And then when we have also insufficiency of written reasons, statutory adjudication, the Act does not expressly want the adjudicator to have reasons in their award. However, the scheme sometimes provides for it. But for FIDIC, it is a requirement that the decision has to be in writing and it has to be reasoned. A PPDA is not so express about the issue of the reasons. So that could be, those are all differing approaches amongst those. Maybe just trying to speed up a bit. The adjudicator's powers and duties under statutory adjudication, Section 1082 sets out the minimum powers of the adjudicator, and also the scheme in paragraphs 12 to 7 give the different duties and powers of the adjudicator. So the adjudicator has a duty to act impartially, can take initiative, can make requests or directions, can seek assistance. The Act may not exactly come out in terms of him getting awarding interest, but the scheme allows the adjudicator to award interest, and that is when the parties actually present interest as an issue, in the dispute. And then, of course, the general power to award damages and the adjudicator's immunity. FIDIC gives the adjudicator also gives the adjudicator powers to establish procedure, maybe even to conduct a hearing, to decide upon their own jurisdiction, to conduct hearing as it thinks fit, and also to act with initiative and get specialist knowledge. Of course, PPDA doesn't expressly point them out, but there are some it points out. For example, because in the clause it mentions, it talks about the jurisdiction, then in inference, it means that the adjudicator can decide upon their own jurisdiction in that kind of way, but it does not expressly come out to talk about issues of initiative. It doesn't also expressly come out to talk about issues of procedure. So maybe that's somewhere we can try and improve. Well, then lastly, we're going to talk about the adjudicator's decision and the different approaches that are taken by these different processes and procedures. So in the adjudicator's decision, we can look at the purpose and nature of the decision. We can look at the structure, format, content of the decision. What is the requirement under statutory? What is the requirement under contractual as applied in Uganda? We can look at reasons. This is something we've already looked at already. Timing, effect, and compliance. So the structure, format, and content of the decision, the act and the scheme do not prescribe any requirements for the structure and format of the decision. FIDIC and PPDA neither do. However, the overarching desire from any adjudicator should be that their decision is clear, concise, and cogent. And then, of course, for reasons, the act does not require reasoned decisions. So the adjudicator could just, give one. However, the scheme provides for, sorry about that. The FIDIC requires the decision to be reasoned, and then PPDA does not express itself about this. So it leaves the parties in line. But I think most adjudicators here in Uganda have tried to give reason awards even in the light of PPDA not expressly coming out to talk about whether it wants the award to be reasoned or not. Timing, the act and the scheme provide for 28 days after the date of receipt of referral notice. And also this deadline may be extended to 42 days by the referring party or longer by both parties. PPDA provides for within 28 days of receipt of a notification of a dispute, provided that the adjudicator is in receipt of all information required, and then there is no extension provided for in PPDA. So that means that the adjudicator has that mandatory requirement to actually give a decision within 28 days. And of course, FIDIC provides for that subclause 20.4 and also any other period proposed by the DAB and approved by the parties, because the DAB also can't function unilaterally without the parties. The parties could say that he acted beyond his jurisdiction and therefore lead to nullity of the award. Then effect and compliance, that is through section 1083, as we've already seen, paragraph 23 in the 2011 scheme. For PPDA, that is part 3, section 7, subclause 25.3. The effect is that the decision is temporarily binding, as we already seen, pending any final determination upon notice of dissatisfaction by any party. So the final determination provided for in the act could be litigation, agreement, or arbitration. For PPDA and FIDIC, for FIDIC, it is amicable settlement, then arbitration. For PPDA, it's strictly arbitration. Then in closing, it should be noted again that adjudication resolves more than 80% of disputes in the construction industry in Uganda. And I think from this, we have been able to see marked similarities and differences between statutory adjudication, PPDA, and FIDIC through the different preconditions to adjudicate, initiating the adjudication, and also looking at the adjudicator's decision. And also overall, if we all read that report about the construction adjudication in the UK from King's College London that was recently published, I think a week back, where they noted that some of the key issues that are leading to disputes in construction adjudication is lack of competence of the parties, and also maybe inadequate contract management practices. So there's need for more sensitization and training of adjudicators in Uganda and also world over. So I thank you very much for listening to me, and I will be looking forward to hearing any questions in the Q&A. Maybe I'll stop the share, Jen.
Okay, thank you very much.
Yes.
There we go. There I am. Okay, yeah, we have 2 questions. The first one is, do you have good examples where adjudication decisions have been enforced in Uganda? Yeah, I guess that's a big thing, isn't it? if you can get a decision, that's one part, but you have to have it enforced.
Yes, adjudication decisions have been enforced in Uganda. That is if they've been made in a correct form of way. But of course, we also had some that have been set aside because of different issues. For example, maybe wrong appointment, inoperable appointment procedures, and also maybe because the adjudicator acted beyond their jurisdiction, and also maybe issues concerning the principles of natural justice, and also issues of bias. So all those are issues, but we have examples, we have instances, many instances where adjudication decisions have been enforced in Uganda. Yes.
Okay, thank you. And the next question is from Gregory. Apart from PPDA and FIDIC, which other standard forms of contract are in use in Uganda, and how do they handle disputes in the first instance?
Yes, PPDA and FIDIC are probably the most common because, let's face it, the public procurement or public works are the biggest, maybe say the biggest employers in the construction industry in Uganda, meaning most of the big projects are either going to use PPDA or FIDIC, depending on the parastatal or the government entity doing the works. And of course, but I know that East African architect standard form of contract, but that is commonly used for buildings in some instances. So that is another that can be used. I am yet to address myself a lot about it, but that is another form of contract that is in use in Uganda, though it is probably restricted a bit more to buildings than to different issues. Of course, FIDIC also faces the same problem in that it hasn't been adopted a lot by the private industry because I think because of different issues. And also PPDA faces the same. So when you find yourself, when you go more into the private work, people are operating maybe with bespoke contracts or without contracts anyway. So that is also an issue.
Okay, and the second part of that question was, how do those other contracts handle disputes in the first instance?
So I think the different ADR methods that are commonly used here in Uganda is if the parties will either try to negotiate, that is deal mediation, or they will, of course, turn to, then probably they will look for an engineer's decision. And then if that fails, they go to, most times, is adjudication, more so in the construction industry.
Okay, thank you. Well, yes. We did have one hand raised, but the person has taken their hand down. And you have cleared the question box. So I guess I'll give a very quick speak now or forever hold your peace. If anyone has another question, just please type it in very quickly. Other than that, I would like to thank you for this in-depth introduction to ADR in Uganda. And for everyone who has attended, if you would like to watch the replay, it will be posted on the website and on our YouTube channel in the next few days. And for all members who have attended, I'll get those CPD certificates out at the same time. And yeah, thank you. Thank you for attending, and thank you, Charles, for that great presentation. I don't see any other questions going into the Q&A box, so I think we'll call it a day. Thank you, everybody, and until next time. Bye.
Okay. Bye.